Good evening, everybody, and thank you so much for coming along this evening. My name is Helen Bock. I am the Community Development Officer, Arts and Culture for the City of Campbelltown. And I love my job here, and I love working with this council, and I love working with this community. One of Council's values that we promote, and you'll see it on our website everywhere, is the word respect. So for tonight's evening forum, that's the theme, a little bit of respect across the room. And looking across the room tonight and the faces I see before me, I do not think that will be a problem. The purpose of tonight's forum is to provide you with information. Information for you to listen to, take away and make your own decisions. It is not a forum that is going to get into any discussion about you should vote yes. It's not a forum that's going to get into any discussion about you should vote no. It's a forum that is going to provide you with information about Constitution, referendum, the Uluru Statement at the heart and the voice. And I ask you all to listen. And if you do have any questions, if we have time at the end of the evening where you need clarification, we will be welcome to take them if we can do so. We've basically got breaking the speakers into two sort of sections. Our first speaker tonight is Stephen McDonald. Stephen McDonald is recognised as one of Australia's leading public law senior counsel. That's very impressive, Stephen. He has appeared in several significant cases in the High Court in the areas of constitutional law, administrative law and criminal law, and joins us tonight to explain the referendum and what it means in legal terms. So, ladies and gentlemen, please welcome Stephen McDonald to the stage.
Good evening and thank you for inviting me to speak tonight. I'd like to acknowledge the Kaurna people as the traditional custodians of the land on which we're meeting and the Adelaide region, and to express my respect for First Nations people who are present with us tonight. And thank you especially to Sean and Cheryl and Russell for sharing your stories. I've been asked to speak about some of the legal aspects of the proposed Aboriginal and Torres Strait Islander voice. There are three broad topics. Firstly, the referendum process. Secondly, a little bit of the history of First Nations people and the Constitution. And thirdly, the proposed amendment itself, what the voice would do. So in Australia, we have a very wide range of different levels of understanding of our Constitution and of public law. So forgive me if anything I say seems too basic. I don't want to oversimplify things and potentially be misleading either, so you'll have to also forgive me if I say anything that seems a little bit too legalistic. So I'm going to try and stick to basically legal issues to the extent that it's possible to separate them out from political issues. So starting with the first question, why are we having a referendum? Well, the reason goes back to federation and the Federal Compact, struck between the colonies that came together to form the Commonwealth of Australia. In the 1890s, there were a series of constitutional conventions attended by delegates from the various Australian colonies, which were to become the Australian states. And there were obvious benefits of joining together in a single nation, for example, common defence and free trade, but also concerns to make sure that the states retained their own autonomy. So they were debating a federal constitution, the creation of a nation made from the union of pre-existing bodies politic. They had the examples of the United States and Canada to draw on, and they also wanted to retain the British system of parliamentary supremacy and responsible government. So a balance had to be struck between the interests of the more populous states and the smaller states who wouldn't want to join the union if their voices were just going to be overwhelmed by majorities from New South Wales and Victoria. So we see that federal balance struck, for example, in the structure of the Commonwealth Parliament, where we have a House of Representatives which reflects the proportion of voters in each state. On the other hand, we also have the Senate, which elect the same number of senators from each state to give more of a voice to the smaller states. So one of the issues that naturally had to be dealt with was a method for amending the Constitution in the future, and the unique mechanism that was chosen was the referendum provision that we now find in section 128 of the Constitution. So to amend the Constitution, you first need a bill passed by the Commonwealth Parliament. That's just like any act of Parliament, and ordinarily it passes both houses of the Parliament. Section 128 does contain a way to bypass that if one of the houses refuses to pass the bill. But in the case of the voice proposal, it was passed by both houses. And then the proposed law has to be submitted to the electors. So that's the referendum, a vote by all enrolled electors in Australia. And Section 128 is a uniquely federal provision. In order to amend the Constitution, there needs to be not only an overall majority of votes in favour of the change, it also has to be supported by a majority of voters in a majority of states. So that's sometimes called the requirement for a double majority. Since there are only 6 states, this means that majorities in at least 4 have to vote in favour of the change before the Constitution would be amended. The votes of residents in the territory, such as the Northern Territory and the ACT, count towards the total number of votes, but they don't count towards any of the particular state votes. The reason behind that was essentially so that the 2 big states acting together couldn't just change the Constitution in a way that suits them at the expense of the smaller states, and equally the small states can't band together to get a change through unless it has the support of an overall majority of voters. Now, it was thought that this amendment process would make it quite difficult to change the Constitution, but not too difficult. And it's proven to be pretty rare for proposed amendments to succeed. Only 8 out of the 44 proposals for constitutional change that have been put to a referendum have actually been successful. I should also mention that there can be other votes on particular issues that are sometimes called referendums, but which are not directed to changing the Constitution. They're sometimes also called plebiscites. Obviously, the most recent one was the same-sex marriage postal survey. That was a vote to collect information only. It was actually enacted and carried out by the Commonwealth under the Commonwealth Parliament's power to make laws with respect to statistics. So it wasn't binding and it didn't change the law. So the details of how constitutional referendums are actually to be conducted are left to legislation that's enacted by the Commonwealth Parliament, namely the Referendum Machinery Provisions Act. So I won't go into that in too much detail, but there's been some public discussion about the question that appears on the ballot paper and also the method of casting votes. So I will address those aspects briefly. So first, the question. The question which every Australian voter will be asked to answer is in these terms: a proposed law to alter the Constitution to recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. Do you approve this proposed alteration? So what we're being asked to say yes or no to is the proposed law that the Parliament has passed, should that take effect to amend the Constitution. That's why the question is framed in that way. Those words are not attempting to be a complete description of the constitutional amendment or the content or the way it will operate. It's what it does is set out what's called the long title of the proposed law. So that's completely orthodox and it's in accordance with what the law requires. So the second issue is the method of voting. So again, the relevant legislation, the Referendum Machinery Provisions Act, is very clear and simple on this. There is a single box, which you can see up on the pretend ballot paper there, and the way that you vote lawfully is just to write either yes or no in the box. And the ballot paper itself tells you to do this. So those are the only 2 ways that you can vote in accordance with the requirements of law. But electoral laws also include what are commonly called savings provisions. And the point of such provisions is try to give effect to voters' intentions even if they don't comply with the formal requirements for valid voting, but they do make their intention clear. So this is what's given rise to some recent debate because of one particular situation. If you put a tick in the box, that is considered an unambiguous vote for yes. If you put a cross, that's less clear because in some situations you can actually vote for a proposal or for a candidate by putting a cross in the relevant box. So that's been regarded as ambiguous. So the treatment of ticks and crosses in that way was confirmed by a federal court decision that was handed down last week in a case brought by Senator Babbitt and Clive Palmer. So that is definitely the current position on it. So potentially that does create a sense of lopsidedness, which is why it's been used to create a political controversy. But you need to remember this is a very small proportion of votes that we're talking about. This is only relevant to people who fail to follow the simple and clear instructions to vote in one of the two legally acceptable ways. And now attention's been drawn to it, it's perhaps even less likely that people will inadvertently vote in the wrong way. Incidentally, this is the same rule that's been applied since 1984, and a similar rule has applied since 1919. And the Parliament was aware of this exact issue in 1989 when it considered changing it and decided not to. So, to sum up, just write either yes or no in the box. So, my next topic is the history of Aboriginal and Torres Strait Islander people in the Constitution. There's a lot that could be said about this, but I'm going to be very brief and superficial. So in the 1890s, the draft Constitution was written and debated and rewritten by colonial leaders of the time, including prominently the Premier of Queensland, Sir Samuel Griffith, who later became the Chief Justice of the High Court, and Sir Edmund Barton, who became Australia's first Prime Minister and one of the original judges of the High Court. The conventions didn't include any Torres Strait Islander people or Aboriginal people. The people of the colonies voted in favour of adopting a new constitution. At that time, Aboriginal men were able to vote in all states except Queensland and Western Australia. South Australia was the only state at that time with universal adult suffrage, so no women could vote in the other states. Aboriginal women could vote along with other women in South Australia. After Federation, Commonwealth electoral laws initially just picked up the franchise from each state, so there was different treatment of First Nations people as well as women across the different states. And so when the Constitution was first enacted, there were only two references to Aboriginal people. The first was section 5126, known as the race power or the races power, and that was a grant of power to the Commonwealth Parliament to make laws with respect to the people of any race for whom it's deemed necessary to make special laws. And as originally enacted, it included the limitation other than the Aboriginal race in any state. The races power was included in order to allow the Commonwealth Parliament to make racially discriminatory laws, for example, to regulate migrant workers of particular races such as Pacific Islanders or Chinese people. That was the reason why it was put in the Constitution. The original exclusion of Aboriginal people from the races power was because issues relating to Aboriginal people were seen as being something that was more appropriately left to each state to decide for itself. Remember, this was a federal compact. It was mostly concerned with the balance of power between the Commonwealth and the states, between central power and state autonomy. And so as the difference in the voting laws at the time shows, there were different views among the different states about how to treat Aboriginal people. In Section 5126, Section 5126 was amended in 1967 by referendum to remove the words that excluded Aboriginal peoples from the race power. And this reflected a recognition that the Commonwealth Parliament should have power to make laws that assist Indigenous people, but it granted a power that was the same kind as the existing races power, that it could be used to make laws for the benefit of or to the detriment of the people of any race. So this was removing a specific reference to race and to the Aboriginal people in particular in the Constitution. So in one sense, making it facially neutral as to racially neutral on its face, but it didn't completely remove racism from the Constitution. The Commonwealth Parliament is still granted a power specifically to make special laws with respect to people by reference to their race. The difference is that now extends to Aboriginal and Torres Strait Islander people as well. I should mention that quite apart from the races power itself, the Commonwealth Parliament has a whole load of other legislative powers with respect to lots of other subject matters, and it has the power to make laws on those subject matters that draw distinctions based on race as well. So, for example, the White Australia policy was achieved primarily through the use of the immigration power. So, that's the race power. The other provision that originally referred to Aboriginal people in the Constitution was Section 127, and it provided, in reckoning the numbers of the people of the Commonwealth, or of a state or a part of the Commonwealth, Aboriginal natives shall not be counted. The intention behind this provision originally seems to have been mainly concerned with the practical difficulties, what were thought to be practical difficulties with counting up large numbers of itinerant people. Even around the time of Federation, there were some people who could see that this had a symbolic meaning that it could be seen to bear, that through the exclusion of Aboriginal people from the constitutional census, that was wrong because it didn't reflect their equal personhood. But the fact that most people saw no problem with this probably tells us something about the prevailing attitudes at the time. So by 1967, this was rightly regarded as offensive, and these provisions were removed by the referendum that was held in 1967. So I come now to my third topic, the voice proposal. So the voice proposal has its genesis in First Nations dialogues that were held across the country in 2016 and 2017, culminating in a National Constitutional Convention in Uluru in 2017. The proposal for a First Nations voice to Parliament and Government is one that originated with a representative process initiated and participated in by Aboriginal and Torres Strait Islander people. And so in that sense, it is something that Aboriginal and Torres Strait Islander people are asking Australia for. The proposed alteration to the Constitution would be to insert a new section 129, which will be in a separate chapter, chapter 9. And the proposal consists of an introduction followed by 3 paragraphs. So I'm going to mention just kind of 4 significant aspects of the proposal. The first aspect, which appears in the introduction, is the recognition in the Constitution of Australian Aboriginal and Torres Strait Islander people as Australia's first peoples. The next paragraph 1 requires that there be a body to be called the Aboriginal and Torres Strait Islander voice. The expression shall be reflects constitutional language that's found elsewhere in the Constitution in provisions that create various institutions of government. So, for example, Section 71 provides that the judicial power of the Commonwealth shall be vested in a federal Supreme Court to be called the High Court of Australia. In one sense, the High Court was created by the Constitution, but like the voice, it did require legislation to actually bring it into effect, practical effect. So if the amendment was passed, the voice would be constitutionally required, but it won't have a concrete existence or practical content until the Parliament makes laws providing for its composition. Paragraph 2 identifies the core function of the voice. The likely legal effect of this is to guarantee that the voice has the capacity to make representations to the Parliament and the executive government. The Parliament could not take away that capacity, but it can regulate it and it can make provision for how it is to be exercised. So the language of make representations was carefully chosen. It's designed to confer a function on the voice and not to create any reciprocal obligation on the Parliament or the executive to do anything in particular with the representations. So the effect is to create what has appropriately been described as an advisory body or an advisory committee. Its primary function is to tell government what it thinks about issues affecting Aboriginal and Torres Strait Islander people. The fact that it has said something doesn't automatically create any legal obligation to do anything, whether procedural or substantive. The voice would not necessarily have to present a single position on every issue. A representation could include more than one view held by Aboriginal and Torres Strait Islander people. It's clear as a matter of legal power that the voice would not have any power to require the Parliament to do anything or to veto any laws made by the Parliament. Some people have talked about the voice having a power of veto. If that's meant as a legal power to stop the Parliament from doing something, which is what a veto normally means, then legally that is wrong. The only power of the voice to require the Parliament to do or not to do anything would be whatever political power it has. Some other people have also used the expression a practical veto. So it's not really clear what that means. It may just mean that politicians might consider it politically compelling for them to have to take into account what the voice has to say and respond to it or even comply with it. In that case, that's a political judgment, and on some issues what the voice says may be practically compelling politically. If the concept of a practical veto is supposed to mean that the voice could stop legislation passing by, for example, measures like holding up Parliament, holding Parliament to ransom, stopping the proceedings of Parliament, that is not legally correct. So turning to paragraph 3, paragraph 3 would confer particular legislative power on the Commonwealth Parliament. It enables the Commonwealth Parliament to make laws that relate to the voice. Again, the language chosen echoes language used elsewhere in the Constitution. We know that the words "with respect to" are understood as giving a broad power to make legislation. It's legislation with a sufficient connection to the voice. Are there limits on this grant of power? Yes, probably. The composition of the body must be such that it does meet the description of an Aboriginal and Torres Strait Islander voice. So a single non-Indigenous person appointed by a minister is probably a clear example of something that would not probably meet that description. And if it was challenged in the High Court, legislation that said that, the High Court would probably say that doesn't comply. So there is, as constitutional lawyers like to say, some minimum content to the constitutional concept, but within pretty broad parameters, the way that the voice is designed and chosen is a matter for the Parliament to decide. It need not be necessarily wholly elected. It could be. That's up to the Parliament. In general, that is fairly consistent with other aspects of our constitutional arrangements. For example, provisions relating to the High Court require that the court exists. They include certain minimum requirements for independence of judges. But beyond that, it's left to the Parliament to make laws deciding what other courts should exist, how many judges there should be, how many judges should sit on each case, what jurisdiction and powers each court should have, and within limits, what procedures should be applied. Similarly, in relation to elections, there are broad minimum requirements in the Constitution. Members of the House of Representatives and Senators must be chosen by the people, that's the expression. But almost all of the detail about elections, who exactly has the right to vote and so on, is found in legislation of the Parliament. And likewise, you find general grants of legislative power with some broad constitutional limits, such as general powers to make laws with respect to taxation or trade and commerce, but coupled with provisions that impose limitations by preventing discrimination between states or parts of states. So there's been lots of discussion about whether sufficient detail has been provided about the proposal. The detail is really what will be the subject of legislation by the Parliament. So matters such as the number of people constituting the voice and the manner in which they're chosen are deliberately left out of what goes into the Constitution, which is what we're voting on, so they can be debated and changed over time. That said, it's entirely understandable that people will want to have some understanding of what kind of body we could expect the voice to be. What would be the model of the voice? So one example of a model that was developed is that which was proposed in the Indigenous Voice Co-Design Process Final Report, commonly referred to as the Langton-Karma Report, which was commissioned by the previous government and presented in July 2021. So I'm not necessarily putting this forward as the model, but the proposed model in this report had a voice that comprised of 24 members, elected by 35 local and regional voices, most of which were would have been made up from existing Aboriginal corporations or groups, institutions. The model took into account a complex range of practical and cultural considerations and featured representation organised partly but not wholly along state lines and territory lines. So because this would be a matter for Parliament, this report shouldn't necessarily be treated as being the precise model that would be adopted, but it's, if you're interested in seeing detail, it's a very useful report in that it shows real insight into the kinds of considerations that would need to be taken into account and the sorts of design considerations that would go into creating the voice. It's about 272 pages, so, but there's also an executive summary. So I might move to section back to section 129. Sorry? Oh, yeah, that's cool. That's where I'm meant to be now. One aspect of the voice proposal that's produced some debate is the function of providing representations to the executive government as opposed to just the Parliament. So in the Constitution, the concept of executive power basically means governmental power that is contrasted with judicial or legislative power, so not what the courts do and not what the Parliament does, but basically every other function of government will come under the head of executive power pretty well. And so, in the first instance then, it will be for the Parliament to make legislation that provides for how the voice may make representations to the executive government. For example, the Parliament might provide for the voice to make representations to Cabinet several times a year or to a particular minister, and it could impose obligations on ministers to pass the representations on to other appropriate organs of the executive government. it wouldn't necessarily be limited to one way of communicating with the government. So again, there must be some minimum content to this constitutional idea. A law that said the Voice could only send a one-page memo to the Prime Minister every 3 years would presumably not meet that requirement, but there's going to be significant leeway for choice for the Parliament to provide as to how representations will be made to the Executive. So as with the Parliament, if the Voice makes a representation to the Executive Government, the Government will not be bound to do anything with it. The Government could accept it, they could reject it, they could take it into account but choose to do something different. The only consequence of government inaction will be political and not legal. Some people have suggested that there could be High Court litigation about the Voice and it could clog up the courts and grind government to a halt. The first part of that statement is definitely true. There could be, and I think almost certainly would be, some kind of litigation. It's hard to see how the second part could be correct though. So the High Court hears and decides about 50 cases each year. It essentially controls its own workload. It deals with lots of applications from people who want the court to hear their case, but the court only hears cases very selectively. Sooner or later, someone will, if the Voice becomes a reality, someone will ask the High Court to rule on one or more issues relating to it, and the court would certainly be expected to decide those cases. Realistically, it might have to deal with a few cases about the different aspects of the Voice over a few years, and depending on what issues arise, cases might continue to be brought sporadically into the future. So that might mean, for example, that the High Court hears 1 or 2 less contract appeals or criminal appeals in a particular year. It wouldn't make a significant difference to the court's workload. Once the High Court has settled relevant legal principles, if there are future cases where those principles come to be applied, then those cases would probably be heard by the Federal Court. That's a court that has about 55 judges across Australia and decides about 1,600 cases a year across a really wide range of legal areas. It deals with a lot of administrative law cases. For example, it deals with hundreds of migration appeals each year. So any litigation involving the Voice would not be a significant addition to the workload of the courts, and there's really no reason to expect that it would hold up government. So finally, one particular issue that's been the subject of public debate is whether individual decision makers would be required to have regard to representations from the Voice in making decisions. So one of the concerns here is that the Voice could bombard a decision maker and make them take a long time to make a decision, or alternatively, that if they didn't take it into account, their decision might be invalid and they might have to make it again. So this is a suggestion that's based on a principle that does exist in administrative law that requires decision makers to have regard to relevant considerations when making a decision. So I have on the slide here a very well-known passage from a judgment of Sir Anthony Mason, a former Judge and Chief Justice of the High Court, which has been repeated and applied many times. This is very orthodox law. So basically, relevant considerations in the administrative law context has a kind of technical legal meaning. And what it means is not just anything that is in fact relevant, it means matters that are required by law to be taken into account by the decision maker in relation to a particular kind of decision. So what those matters are depends upon the particular legislation that establishes the decision-making process in question. And so what they are in a particular case will depend upon what the Parliament has said in legislation about that specific kind of decision. So it's clearly within the Parliament's power to say, for a particular sort of decision, say, for example, a decision to grant a mining licence where there are Aboriginal heritage sites in the area, that a decision maker is required to consider any representations made by the Voice. But equally, the Parliament can make it clear that there is no such requirement in relation to particular decisions. So this is essentially the same position that already exists. The Parliament can dictate whether you have to have regard to particular considerations in making a decision or not. The default position, according to well-established administrative law principles, would be that a general function of making representations to the government would not impose an obligation to have regard to those representations in relation to specific decisions. But again, a matter for the Parliament ultimately to control whether that is the case. Those are the issues that I was going to mention. so probably got a bit over
That's
time.
very good.
Thank
You have gone over time. You naughty
Sorry.
boy.